We all know that expression must be original to be eligible for copyright protection. But surely protected works take shapes and other elements from the public domain. So how is all this evaluated from a copyright infringement perspective? The 2003 case of Tufenkian Import-Export Ventures Incorporated versus Einstein Moomjy Incorporated explores some of the relevant considerations in a tale of two carpets. James Tufenkian was a manufacturer and designer of carpets. In 1995, Tufenkian registered the copyright for one of the designs he developed a couple years earlier called the Heriz. The Heriz included motifs from two designs already in the public domain. The first was a well-known antique Persian rug design, and the second was a famous Indian carpet design. The resultant Heriz's main field area came from the Persian rugs design, though Tufenkian elongated it, removed several elements, and placed it off-center for an asymmetrical design. The Heriz used the Indian carpet's main border, along with smaller border elements created by Tufenkian. That same year, Bashian Brothers, also in the carpet business, hired a former Tufenkian employee to oversee the design of a carpet called the Bromley. 2 years after the Heriz was marketed, the Bashian team began work on the Bromley, which also featured a main field area from the Persian design and a border from the Indian one. It did, however, add a beetle-like image to its symmetrical design and modified the Indian carpet's border differently from the Heriz. It also culled out different elements from the Persian field design. Nonetheless, the resultant Bromley looked substantially similar to the Heriz. The Bromley team admitted to being familiar with the Heriz and copying it in some respects. Tufenkian sued Bashian in district court for copyright infringement, seeking injunctive and other relief. Although the court found that the Heriz copyright was valid and that the Bromley copied it, it determined there was no infringement. The court found that the two rugs had different overall feel and that any substantial similarity between the two designs was attributable to unprotected elements that were already in the public domain. As such, the court granted Bashian's motion for summary judgment and dismissed the case. Tufenkian appealed to the Second Circuit.